Our second panel, which is dedicated to the International Criminal Court. As we already heard, Jerzy Kyriakosyan was already addressing some aspects about the Armenians' membership to the ICC. And today in this panel we are exactly going to discuss the roles and responsibilities of the new state party to the ICC. And of course I'm very much happy and very much honored to have distinguished panelists here that had time to come to Armenia and to share their experience. What we are going to do together in this panel, generally we are going to examine or discuss together from different angles, from the prosecutorial perspective, from the complementarity perspective, from the cooperation perspective, and of course at the end we will look at what exactly is being done in order to fulfill the requirements, in order to be a full member to the ICC. So I'm really happy that the distinguished panelists here, very experienced persons in their fields that are going to share their ideas about these topics. In order not to lose too much time, and we will have then a little bit more time for a discussion, I wanted to remind you that our volunteers will be around, so if you will have any question, you can just write on the paper, and then I will address those questions to our distinguished panelists. So our first panelist is Mr. Peter Kremer, who was previously served as a Director and General Counsel of the Canadian War Crimes and Crimes Against Humanity section from 1996, and he was the Chief of the Appeals from 2005 to 2014, and the Acting Deputy Prosecutor from 2012 to until 2014 of the Office of the Prosecutor of the International Criminal Tribunal for the former Yugoslavia. So we have a very experienced prosecutor here who will share some ideas about how to prosecute and what are the responsibilities of the prosecution. Thank you very much, Mr. Kremer. The floor is yours.
Thank you, Gurgen, and thank you for the organizers of this conference. I'm very pleased to participate and honored to be able to share some insights into what's ahead for Armenia, as it is now a state party to the Rome Statute. When Gurgen first asked me to speak, I wavered because my international criminal law experience was not acquired at the ICC. He convinced me that my blend of management, investigative and prosecutorial experiences at the national and international level could benefit my being able to offer helpful comments on what lies ahead. And so I've structured my talk to deal with some of the issues that we encountered, some of the positive things that happened during the investigation and prosecution of war crimes at the two institutions I was at, and give you some best practices that you might want to consider in moving forward. Just because it hasn't been mentioned yet, I'm going to focus on territorial jurisdiction, which gives primary competence to prosecute international crimes to the state on whose territory the crime was committed or where the accused resides or is found. So Canada could prosecute anyone for any crime that was committed in its jurisdiction. Or in our case, when we were dealing with Nazi war criminals, they were residing in Canada at various locations. Universal jurisdiction gives the state competence over genocide, crimes against humanity and war crimes, and Canada to make sure that we could prosecute in Canada these crimes. We passed an amendment to the criminal code. And from that point on, we were committed to prosecuting Nazi war crimes in Canada. The ICTY, as you may know or may not know, is an ad hoc tribunal created by the UN Security Council in 1993 to prosecute mass atrocities that occurred during conflicts in the Balkans in the 1990s. The ICTY statute gave it primacy over national courts and the power to formally request national courts to defer to the competence of the ICTY, and that occurred very early on with a request to Germany over the accused Duško Tadić. The Rome Statute established the ICC to investigate and prosecute serious international crimes and is complementary to national criminal jurisdictions and their investigations. Canada became the first country in the world to incorporate the Rome Statute provisions into its national laws when it adopted the Crimes Against Humanity and War Crimes Act to ensure that Canada could fully cooperate with ICC proceedings and take advantage of the complementarity provisions under the Rome Statute. So the best practice for me to recommend to Armenia, which I think you have done, is to incorporate the provisions of the Rome Statute into domestic legislation. One of the early problems for the Canadian War Crimes section was who's in charge of the investigation. The Canadian War Crimes section was established in 1988 based on the traditional common law model where the police investigate and prosecutors solely carry out the courtroom proceedings. The Royal Canadian Mounted Police, without horse, and the Department of Justice created separate war crimes units. The ICTY OTP initially used the same model from 1994 to 2001. In both cases, this split responsibility model proved inadequate for these complex investigations, particularly of high-ranking political, military, and security police chiefs far removed from the actual crimes. In 1992, a structural change was negotiated with the RCMP to have DOJ, Justice senior lawyers, lead the investigations. And in 2001 and 2002, the ICTY implemented a similar change with senior trial attorneys being assigned to lead the investigations. The best practice, based on the experience afterwards, is that senior prosecutors, not police investigators, should be in charge of the investigations and prosecution. And by senior, if possible, your best senior prosecutor. Dealing with staffing of an office, this was also a problem, at both institutions. The selection of appropriately skilled professionals is vital to successful investigation and prosecution of international crimes. They are complex and require professionals who have direct previous experience in international criminal law and other relevant experience in investigating or prosecuting complex crimes with multiple suspects in domestic jurisdictions. A joint Department of Justice and RCMP audit on ongoing investigations led to restructuring in 1992. It demonstrated the need to strengthen the investigation and prosecution teams by adding more experienced and more competent investigators, prosecutors, and other staff members. In 2001, under Carla Del Ponte, the ICTY prosecutor, she followed a similar staffing renewal. The investigation teams at that point, after the restructuring, under the leadership of the senior prosecutors, incorporated historians, political analysts who knew the history and the background of the conflict, and the key perpetrators, military, intelligence, and area analysts, experts who spoke the local languages, and dedicated case managers. The recommendation I have is get the staffing right from the beginning, because it's going to stop your investigations and you may have to start again from the beginning. An experienced prosecutor should be appointed to lead the investigation and given the authority to staff the office. All staff members must be hired on merit, have the necessary skills to deal with large, complex cases, and be subject to ongoing and meaningful performance review. And before investigation and prosecutorial work starts, an evidence unit must be staffed and clear direction be given for how the evidence is to be organized and structured. Senior management should draft concise written investigation and prosecution plans that define tangible and attainable objectives for the prosecution teams and for the office. Develop strategic plans for selecting suspects and identifying crimes. Identify possible experts for retention on a short-term basis as needed, and make sure the team includes the appropriate balance of case management support as well as investigative and legal and analytical capacity. In Canada, in the world, in 1991, 1992, there was a changing international political environment that created opportunities for greater cooperation at the investigative stage. Initially, starting 1988 till 1991, Canada's investigations were conducted mainly in Western countries like Germany, USA, Israel, Austria, Poland, etc. The cooperation with the Soviet Union and East Bloc countries was deemed essential for our investigations. Why? The Soviets held captured German records, reports of post-war Soviet investigations and trials of Nazi perpetrators and collaborators. Before the breakup, cooperation was through formal diplomatic legal assistance requests to the Procurator General of the USSR. Responses, when received, often months later, were frequently inadequate and unresponsive. Political changes in the early 1990s in the USSR created new opportunities for Nazi war crimes investigations. We were fortunate that the new republics were willing to negotiate memorandums of understanding with Canada, and we went to Estonia, Latvia, Lithuania, Ukraine, Yugoslavia, Belarus, and Russia, and were able to facilitate direct access of our historians and analysts to finding guides and relevant archival files in the state, oblast, and to a lesser degree military and KGB archives, direct access to the relevant Soviet criminal investigation and trial records at Prosecutor General's archives, assistance in locating potential witnesses and arranging witness interviews by our investigators and prosecutors, and given the future uncertain stability of the new regimes, we had to do it fast, and we hired additional staff, language experts, and blitzed the countries for 2 years. We did it together with the USA, the UK, Scotland, and Australia, who were also working on Nazi war criminals at the time, and that leads to the best practice: remain open to cooperation arrangements with other partners, regional states, NGOs, international organizations, etc. You never know what's going to happen and when the doors will be open. For now, thank you.
So fantastic. Thank you very much, Mr. Kremer. This is, of course, very much interesting, and I think in our discussion we'll go deeper about this experience from Canada and ICTY. Moving to the second topic, as I mentioned in the beginning, the first one is the prosecutorial perspective, and the second one is, of course, to cooperate with the states. And here we have Dr. Sara Babaian, a very good friend of mine, where we, within the German-Armenian Lawyers Association, had already started this cooperation idea in order to trigger or motivate the states, especially Armenia, to cooperate also with other states in relation to the prosecutorial issues. So Sara Babaian will speak mostly about this cooperation part. And Dr. Sara Babaian was born in 1991 in Hamburg. Her father is Armenian and her mother is German. She completed her law studies at the Hamburg University and also continued that in the Geneva Academy of International Humanitarian Law. And later she also completed her promotion or dissertation at the Hamburg University. She is a mediator, a certified mediator. She had a huge experience in working in international law, such as the United Nations High Commissioner for Human Rights, European Center for Constitutional Court, and Constitutional and Human Rights Center in Berlin. She was a legal advisor and business mediator in different law firms, but also a very important point to mention that she published also a lot on the International Criminal Court and especially on the cooperation issues. And one of her recent publications is the International Criminal Court and International Criminal World Jurisdiction and Cooperation Mechanism of the Rome Statute and its practical implementation. So we have an expert here on the cooperation issues. So Dr. Babaian, please, the floor is yours.
Yeah, perfect. Thank you so much for the nice invitation also here. Thank you, Gazia. It's always delightful to be here. Yes, I'm very happy to talk about the cooperation mechanism of the Rome Statute. First and foremost, with regard to the Republic of Armenia as a new member state. So, to make it a bit easier, I would like to start with the structure, just a very short overview of the International Criminal Court. So it is established on a judicial pillar and an enforcement pillar. In the enforcement pillar, we will find the cooperation. So we can say the judicial pillar is quite strong, because the Rome Statute is quite strong. But coming to the enforcement pillar, talking about cooperation, it is something else. Why it is that? Because the ICC does not dispose of a police force, nor does it have any kind of executive powers to enforce its decisions. So it is made distinctively or entirely dependent on states. What does that mean? It was due to the Realpolitik at that time, when they established the Rome Statute, that states decided to give the whole cooperation mechanism into their hands, and this was due to the protection of their sovereignty, as always. So to date, the biggest challenge for the ICC remains ensuring sufficient cooperation of states. And to call it in the words of Philip Kirsch, who was one of the first presidents of the ICC has no army, the ICC has no police. That's what states wanted, and having wanted that system, now states need to cooperate with the court to ensure that the system works. Good for now, but this is the main challenge. So I'm talking about the cooperation and judicial system. It's a part 9 of the ICC statute, and due to the time limit we have today, I just can jump into some of the most important provisions of the Rome Statute. So we have general provisions, arrest and surrender, one of the most important provisions, and other forms of cooperation, and general provisions. Part 2, this is a bit mixed up because it was also due a time limit at the Rome conference at that time. So, as we can see, We have the general provisions, Articles 86, 87, and 88, and 86 and 88 are the most important ones. Why? Because pursuant to 86, there is a general obligation to cooperate with the court. This was very important, especially at that time, to include such a cooperation mechanism and to make it an obligation so that it's not on the state to determine whether they want to comply or not comply with the requests of the court. And because they wanted to circumvent such neglection, they included the paragraph 88, which says Part 9, so the whole and entire cooperation mechanism has to be incorporated into their own national law. Once more, in order for the state not to not cooperate with the court. And also, as a very strategical move, it was very important so that the state could say, we are applying our own national laws in order to cooperate. So what is Armenia able or obliged to do? Armenia has to cooperate fully with the ICC and ensure that all procedures for Part 9 shall be implemented in its national law. So this is, first of all, very important. Then we have the very important articles, arrest and surrender, 89 to 92. We will just focus now on surrender of persons to the court. What does it mean? So, as I said, first of all, it is a cooperation mechanism, so all the power is within the state, but as trials in absentia are not permissible in front of the court would render it absolutely obsolete if the persons wouldn't be in front of the court. So it is so important that the court can release the request to arrest and surrender. And we have seen what states are doing right now. I mean, we have seen that for the most important case, which was around al-Bashir, the former president of Sudan, who traveled around the world and he was not arrested by anyone, or just what we have seen in Mongolia, where Putin was not arrested, even though there was such an arrest warrant. We will talk about that maybe in the Q&A later, because there are some conflicts maybe, what we will discuss that later. And then we have also competing requests. This is just important for Armenia to determine, are there admissibility challenges or is there another request we have to see? So in the end we can say, with regard to arrest and surrender, Armenia has to comply fully with the arrest and surrender request of the court and guarantee through its national procedure law, again, implement that into the national law of Armenia, that, for example, transportation, custody, etc. is possible. And consult immediately with the court in case of an admissibility challenge or take into account competing requests. Then we have other forms of cooperation. Other forms of cooperation is, except of surrender, also one of the most important ones. It comprises 12 subparagraphs, of which 11 are explicitly mentioned, while one was left open, because, I mean, you cannot just include any kind of assistance, but it was very, very important. And this could be assistance such as taking evidence, service of documents, examination of places, and the list goes on and on and on. So this was very important, and also here it is very important that, for example, Armenia concludes special agreements in order to support the court in all the requests for other forms of cooperation. So, once again, Armenia has to comply fully with the request of the ICC, taking of evidence, service of documents, examination of places, protection of victims, very, very important, transfer of persons, and it has to incorporate these cooperation procedures into the national law, once again, and it has to protect or disclose any kind of documents or evidence except when it relates to the national security, and it has to let the prosecutor execute the request directly on the territory of Armenia. This was also a very important inclusion into the statute. Then, I'm sorry that I'm rushing, but we just have 10 minutes. Then we have the general provisions 95, 97, and 98. We will focus here on 97, which is talking about consultations. What does that mean? Article 97 says that member states have to consult with the court with undue delay in cases where the state is impeded or prevented from executing the request. It was also here you can see that they really wanted to grant the ICC the power, because it is not in the discretion of the state to decide whether to comply or not comply with a court or with a request, but it is on the state, it is on the ICC to do this. And that's why it was very important that they have included such a paragraph. Also to say it's very important that you have the connection and the discussions always with the ICC. Yes, and then we have the terrible Article 98. I mean, it's not that terrible, but now there is a lot of confusion and it's highly disputable how to apply it. What does it say? The ICC may not proceed until with a request if it would require the state to act inconsistently with its obligations pursuant to international immunity things. It's personal immunity or it could be state immunity. They included, of course, that kind of thing of a third state, because as we know, the ICC is a treaty-based body. And I mean, at that time, it was clear that you cannot just say, okay, it can be applied for everyone. So regardless, I mean, when we regard things like third states, it's the question whether the state, the member state, has to comply with the request. We just saw that, what I said with Mongolia, they didn't comply. The question is, did they do something wrong with it or not? But maybe we can discuss that also later on. So in the end, we can say Armenia has to consult with the ICC in cases in which it identifies problems regarding the execution of a specific request and determine in case of surrender or assistance request, which entails a person of a non-member state, which obligation shall prevail. So this is mainly about the ICC. And so now we just have maybe simple, just very quickly, there's also the State Assembly of States Party, and it's very important that Armenia is taking a part of the annual meetings. We will discuss that also later. But to sum it up, it's very important because, as we know, the Rome Statute is very new for Armenia, and it always sounds so easy that you have to implement it. So what is important? It is important. The understanding of international criminal law and the intention of the ICC. Training of judges, prosecutors, and investigators, what is already done by highly esteemed colleagues of us. Incorporation of the cooperation system into the national law, specific cooperation agreements with the ICC, and the consistent engagement with the court, the registry, and the ASP in order to make Armenia a useful member to the ICC. And just a short note, Antonio Caseso, one of the most important international criminal lawyers, once called the ICTY a giant without arms and legs. We just can hope that the cooperation system is improving and that Armenia is dedicated and is really helping to make it a giant with arms and legs. Thank you very much.
Thank you very much, dear Sarah, for also citing Kasese. This is very interesting that we in Yerevan now hear about also this the very, very important name in international criminal law, Antonio Kasese, so it was very nice. So thank you again, Sarah, for elaborating on the cooperation issue. So one thing, as I mentioned, one thing is the prosecution, one thing is the cooperation. An important part is the complementarity principle. This is something that is basis of the Rome Statute and international criminal law in general. So now we are moving to that topic, and this is covered by Dr. Victor Tsilonis, who is the managing partner of Newlaw law firm, and his career highlights include being Greece nominee for 2020 as a judge for International Criminal Court, highly presided by Independent International Advisory Committee on the nomination of judges. He has a long-standing presence in the International Criminal Court Bar Association, serving twice as a vice president and the chair of the Professional Standards Advisory Committee. He's also a pro bono member of the IC disciplinary organs. He has co-drafted over 27% of their published decisions. And Dr. Tsilonis has been adjunct lecturer at the Hellenic Open University from 2022 until 2024. And very important point, that he also published a very important book that was recently, that was a second edition of that book, The Jurisdiction of the International Criminal Court. And very recently, which also allows me to congratulate Dr. Tsilonis, that he was awarded for the 2024 International Science Prize of the Hans-Günther Brau Foundation for Peace and Ecology in the Anthropocene, awarded for his contributions to the legal discourse on ecocide and ICC. So very much thanks to you, Victor, for being with us today, and the floor is yours.
Ladies and gentlemen, esteemed colleagues, I am particularly honored to speak at the third annual conference of the International Center for Truth and Justice at the historic Matenadaran. I would like to extend my deepest gratitude to the organizing committee for this prestigious invitation. Armenia, a land of ancient history, culture and resilience, has been a very important contributor to global culture, politics and law. From surviving invasions, crimes against humanity and genocide in 1915 and more recently, to shaping the discourse on justice, Armenians have shown remarkable perseverance. Legal scholars like Raphael Lemkin, who have coined the famous G-word, genocide, remind us of Armenia's deep connection to the principles of international justice. As we gather here today, it is essential to remember that this legacy of resilience informs the very work we should engage through the International Criminal Court. Now we are going to see the agenda of the proposed agenda of my speech today, which was originally more than 35 slides, and now I have tried to shorten them up to 15. So we have already done this honorary prelude. We are going to speak shortly about the principle of complementarity. The new OTP policy, when I say OTP, I mean the Office of the Prosecutor. I will try not to use this too much because even within the National Legal Councils, this abbreviation sometimes brings a small headache. Then we're going to talk about some relevant articles in the Rome Statute, including complementarity, so articles 17, 18, 19, and 20. We're going to talk about the holistic approach to complementarity, which is specifically referred to the new policy of the Office of the Prosecutor regarding complementarity and cooperation. And I would like boldly to say that I was the first to use this term in an academic textbook. There was a decision of the ICC earlier, but as an academic, I would argue I was first to use the holistic interpretation of the ICC Rome Statute. Then we're going to talk about this new two-track approach that the Office of the Prosecutor has envisaged to follow. We're going to speak about capacity building initiatives, to offer some critique about the application of the complementarity so far until this published policy and before Karim Khan's leadership as a prosecutor. We are going to talk about some practical assistance to national authorities, and we're going to conclude. And at the end, there is also an important notice that I speak only for myself and not as part of the International Criminal Court Bar Association or the disciplinary organs of the International Criminal Court. So thank you. We have talked already about that. At the heart of the Rome Statute, so we're going now to talk about the complementarity. At the heart of the Rome Statute, which governs the International Criminal Court, lies the principle of complementarity. This principle ensures that national jurisdictions have the primary responsibility to prosecute international crimes. And international crimes, stricto sensu, in the strict sense, are only four: genocide, war crimes, crimes against humanity, and the crime of aggression, about which there is no actual jurisdiction of the ICC, but that's another story. The ICC, so, steps only when states are unable or unwilling to fulfill their responsibilities under international law. Article 17 to 20 of their own statute govern the application of this fundamental principle of complementarity. Article 17, the article where the principle of complementarity is founded upon, addresses the admissibility of cases, ensuring that the International Criminal Court, or hereinafter the court, deals with a case only when national jurisdictions fail. That means national jurisdictions, state members, are unwilling or unable to perform their judicial functions and to confer justice. Article 18 concerns deferral of investigations, so the delay of investigations, allowing states the opportunity to demonstrate their capacity to investigate. Article 19 deals with challenges to the International Criminal Court's jurisdiction, enabling states to contest the involvement of the court if they are genuinely prosecuting the crimes. And Article 20 codifies the principle of ne bis in idem, which is a little bit different than the double jeopardy we have in the US, or they have in the US, because ne bis in idem prevents an individual from being prosecuted and tried twice for the same time, while double jeopardy is much more often as a defense. So somebody is prosecuted and he raises the defense. So, let's go back. The new prosecutor's policy is a holistic approach. In April 2024, the Office of the Prosecutor introduced a groundbreaking policy, redefining complementarity. This new policy emphasized a holistic approach, turning complementarity from a procedural safeguard into an opportunity link for cooperation and capacity building. The new prosecutor's policy shifts the court's role from being merely a court of last resort to an active partner in justice. It enables for capacity building and cooperation with national jurisdictions. It proactively engages the court because the prosecutor seeks to actively engage with states to assist them in improving their judicial system, and enhances field presence, since the prosecutor has started and aims to enhance more its presence in the field, ensuring closer collaboration with national authorities. In that sense, the Office of the Prosecutor is becoming increasingly technology-driven, which is one of the new four key pillars in this novel two-track approach the prosecutor wishes to follow. The two-track approach of the Office of the Prosecutor has two sides. The first side is the first track, focuses on using advanced technology like artificial intelligence and information technology to gather, analyze and present evidence much more effectively. The problem is that we have huge volumes of evidence and there is always a difficulty to process and evaluate all this evidence. So with artificial intelligence, this issue can be dealt with effectively. The second track emphasizes collaboration and capacity building with national jurisdictions. Together, these two tracks enable the Office of the Prosecutor to bolster its investigative capabilities and strengthen complementarity. I will leave and I will go, because of lack of time, to the critique of the complementarity principle. Over the time, and since the inception of the Court in 2002, when 60 states ratified it, there have been much critique about the complementarity principle. In my textbook, I explore these critiques in detail. One of the most prominent for me is the counting bodies critique, or maybe counting dead bodies critique. This critique challenges the ICC's historical focus on the number of victims, rather than the impact of crimes on societies. Such an approach has risks and has sidelined cases in the past that have fewer victims. For example, imagine mutantis mutandis, a George Floyd case, that have only one victim, but have a great impact upon society. In Greece, we had the notorious Golden Dawn trial in Greece, which involved the orchestrated crimes of an extremist right-wing political organization with numerous elected members of parliament. In that case, the Greek authorities struggled for over 4 years, to find an appropriate judicial venue, to find a place where the trial would be held. So, as I argue, in this case, the number of victims could not make the court invoke the International Criminal Court about complementarity. The significance of justice should not be measured only by the number of lives lost, but by the ability to hold those responsible accountable and bring justice upon heavily impacted societies. So, the new OTP policy has already seen success in providing practical assistance to national authorities in Colombia, Guinea, Ukraine, and Venezuela. And under this new policy, there have been also cooperation of the court with Eurojust and several European states and the US regarding the Ukraine situation. Now, closing about, and just to sum up about the new OTP policy that it's worth reading, it's almost 100 pages, so it's really a lot to cover in 10 minutes. This OTP policy represents a bold and innovative shift in the court's approach to complementarity. By advocating for a holistic approach and emphasizing the court's role in building state capacity, the policy aims to ensure that the most serious crimes do not go unpunished. The court is moving from being a court of last resort to a proactive partner and seeks to empower national jurisdictions. That could happen with Armenia as well, enabling states to prosecute serious crimes independently and not just crimes, international crimes. So the court, under this policy, can also assist member states for other crimes, not just war crimes, crimes against humanity, genocide, or the crime of aggression, about which the ICC does not have essential jurisdiction so far. So, all this, and as we move forward, it is essential that complementarity evolves in a manner that would be effective, equitable, and just, without undermining the legal principles that form the foundation of the ICC. Ultimately, this policy has the potential to usher an era of true complementarity and foster partnerships that strengthen national judicial systems, while fulfilling the court's mandate to bring justice for the world's most heinous crimes. Thank you so much. Thank you for your patience.
Thank you very much, dear Victor, for, of course, the complementarity is one of the biggest topics, and of course in 10 minutes it's impossible to cover anything relating very much. But Victor, you've done a great job in 10 minutes, especially giving us some idea how this complementarity principle works, and I think we're going to dive into that topic in a few minutes. So the next topic is, of course, to understand at what stage actually Armenia is standing and what has been already done. It has been already 1 year that Armenia is member to the ICC, and this is something that is going to we are going to explore with Lucine Hakopian, very good colleague of mine that was also an active advocate for the membership to the ICC. She is also founding member, and since 2011 she is a president of European Law Association, that has been invited to sit in a technical committee of the Council of Europe project Support Justice Sector Reform in Armenia, being one of the only 2 civil society representatives to be invited to sit in the committee. In the period of her presidency, Ela was twice the recipient of Universal Rights Award in recognition of its outstanding efforts in protecting the electoral rights of Armenian citizens. And from 2019 until 2022, Ms. Hakopian was the national facilitator of the Armenian National Platform of the IEP Civil Society Platform. So she has huge experience from the civil society perspective, and I think this is the experience that has to be shared by Lucine Hakopian is very much expected. Thank you very much, Lucine, for being with us, and the floor is yours.
Thank you very much, Gurgen. I would also like to first extend my words of gratitude to the Center for Truth and Justice, to Gurgen and all the other organizers of this important conference. It is a pleasure and an honor for me to address you, distinguished audience, together with my esteemed panelists here. I will say a few words about the efforts the Armenian government has put in ratification of the Rome Statute and now the implementation. I will also dwell upon the role of civil society in these efforts. As you know, you may know, the Armenian diplomats were very active at the stage of negotiation of the Rome Statute, but then for some to civil society's assessment, political reasons, it was decided not to ratify the Rome Statute in the beginning of 2000s, and conveniently the Constitutional Court back then declared the obligations undertaken under the obligations within the Rome Statute unconstitutional, and therefore we had to go along a very long path until we reached the date of ratification of the Rome Statute, and civil society was very active in pushing for and advocating for the ratification of this important international instrument, and we were really happy that finally the government decided to apply to the Constitutional Court once again. You will have Judge Seda Safarian tomorrow, and she will speak in more detail about probably the decision of the Constitutional Court. But here I would like to state that we were really impressed by the stance taken by the Constitutional Court of Armenia, which said that considering the Armenian constitution, the preamble, and the struggle of the Armenian people for the recognition of the Armenian genocide, it's basically a civilizational obligation for Armenia to join the efforts of the international community in fighting against international crime of gravest concern. And we were, I think it is not even necessary to say that we were very happy with finally the decision of the Armenian parliament to ratify the Rome Statute. And following this, the Armenian government undertook an assessment of the needs, a needs assessment of what the country needs in the process of implementation of the Rome Statute. And basically several needs were identified, including expert support in amending the relevant Armenian legislation to comply with Armenia's obligations before the ICC, to take action in the area of capacity building among the professionals, including judges, prosecutors, investigators, police, as well as awareness raising among academics and students. And with this, the government applied to, among others, also several international partners, and one of the partners that responded very fast to this was the Dutch government, unsurprising considering that the ICC is based in The Hague, and currently with ELA's involvement, the organization that I represent, the Armenian government is engaged in the process of amending its legislation. Just to inform you that there is a draft law on cooperation with the ICC on the table, and basically, to my knowledge, this has been sent also to the ICC, and also ELA has involved prominent experts to, and we're very thankful to Gurgen Petrossian for his also contribution in this process to advise the government on the necessary amendments to this draft, as well as other related legislation. For you to know, in 2021, the Criminal Code of Armenia was brought in line with the ICC provisions, and now not an argument, but some disagreement, there is some discussion probably between experts whether there is need for the criminal procedure code to be amended, or whether whatever we have there is sufficient to consider that we are compliant with our obligations under the Rome Statute. Other than that, there is another component within our project on supporting the Armenian public officials with capacity building, and again, we have conducted, the government has been has participated in different trainings, and one was again organized with Gurgen Petrossian's assistance for different representatives of the Armenian public institutions, including members of parliament this summer, and we also had Honorable Judge Joanna Korner as a speaker for this workshop, and I know that there will be other workshops also by other organizations, and ELA will organize several other workshops for different groups of public officials, separately for judges, prosecutors, investigators, police officers, members of parliament. I know that there are other colleagues, other organizations that are also doing something in the area of capacity building for civil society. And another important commitment and component is to support the government in developing legal resources for academics and students. There will be a user-friendly manual for, again, the same public officials, and also we are in the process of selecting a textbook by renowned international authors to make it available in Armenian, and also to make it available to the law students of Armenian universities. And I think it was very important to mention, it is important to mention that the process of ratification of the Rome Statute was accompanied by fears, disinformation campaign by Russian proxy circles especially, and I still remember the date when the parliament was debating the ratification of the Rome Statute. We were having Facebook posts on, oh, Russia has closed the last corridor, they are not accepting Armenian cognac, etc., etc., and creating all sorts of fears, but above all, just trying trying to make an impression that the Rome Statute is only about the arrest of Vladimir Putin and Armenia shouldn't ruin its relations with Russia. So considering all these like fears, rhetoric and negative campaigns, we also decided to do something about like positive campaign to prepare some video materials, programs on the importance of the ICC and also the importance of Armenia joining the ICC, what ICC can get from Armenia, what Armenia can get from becoming a full member of the ICC. And finally, to mention that it made me very happy that yesterday the Armenian parliament also ratified the Eurojust agreement, and this is also another important step in fighting in the joint efforts with the EU and other civilized states to fight international crimes. And I know that there will be a delegation from the Eurojust in Armenia at the end of this month, and hopefully the working arrangements between Armenia and Eurojust will be signed then, and then Armenia can have a liaison prosecutor in Eurojust, which will again strengthen the cooperation in this area. And I know I've run out of my time, so thank you very much for your attention.
So thank you very much, Lucine. Now we are moving to our Q&A session. I just want to remind you that our volunteers are around, so if you have any questions, you can just write them on the paper and I will address them to our speakers. So, Mr. Kremer, my first question goes to you as soon as you mentioned about the structured the prosecution office, and you mentioned about the senior officers, how the persons should be allocated, who exactly should do the work. But then the question arises how to start the investigation, because if we consider the international crimes, they are not similar, they don't have the similar investigation as they have on the international level. You need a huge amount of evidence. How to deal with those investigations when the crimes are happening not on your own territory but outside of your borders? How to do, or you don't have the access to this direct evidence? What are those strategies that you have used in your career? Thank you very much.
That's problematic, of course. That if you can't go on site to investigate the crime, you have to collect evidence from witnesses who are no longer on the territory where the crime took place. That's Nazi war crimes, the crimes that took place in Russia. We couldn't initially go to Russia and investigate. But we talked to witnesses who were still alive, and that was an additional problem. And so we had to fly around the world once we identified witnesses with the assistance of police in those jurisdictions. We had documents that the Germans had collected post-war, that the Nuremberg tribunals collected post-war, that the Americans had in the U.S. archives. So there was a body of evidence of the crimes, of the investigations of those crimes by other international courts and domestic courts, but we still had to identify who we had. We had people who are alleged to have committed war crimes in Canada, but we still had to prove it. And the difficulty you have, sometimes you can investigate a situation, but you don't know who's responsible. And so you have to find out who's responsible. Sometimes in the mobile killing units in Germany, they went from place to place killing everybody. And there were no survivors. And so the only opportunity was to find a member of the killing unit who was alive and willing to testify against his colleagues. In some cases, that proved impossible. In other cases, it proved to be possible because the people had come to the realization that they had to get it off their chest. In some cases, the German police knocked on the door and the person said, "I've been waiting for you so I can tell the story." Told the story, got to other people in the unit, and the case was put to bed. In some cases, the units had already organized themselves, and there was a protection group that made sure that the people didn't talk. So it's hard, but when you have political changes like we had in Yugoslavia, we got access to Croatia, we got access to Serbia and so on, and it makes the investigations a lot easier. But with Azerbaijan, I don't know what the situation is. It may well be that you can use the ICC provisions to have them give a request and try to use it to put some pressure on them. But, I think you have to start at home, get as much evidence as you can, be patient until you have the opportunity to get further evidence.
It's interesting that you make the comparison with the Nazi crimes. In case of the Nazi crimes, of course, there is a Nuremberg judgment, and it is some kind of already guiding the domestic authorities in which direction they should go. There is no need for these chapeau elements to go very much into the details. But if you have a new conflict and you are dealing with a conflict which doesn't have any judgment yet in order to understand the contextual element of particular country, how difficult is it for the prosecutors to collect or to collect the evidence that is enough to say that these contextual elements are there? I will bring an example. In very often when I spoke to the prosecutors at the ICTY, how much evidence you need in order to prove the forest. Do you need to go tree by tree in order to say there is a forest, or just one particular picture from upstairs is enough to say that there is a forest?
I think in Rwanda, the courts finally said there is a forest and we'll take judicial notice of it, but it has to be proven at the beginning. In Germany, the Nuremberg trials and the subsequent trials didn't prove all of the crimes. The amount of crimes committed on European territories by the Nazis was staggering. And there were groups that had committed crimes that there were only stories about, but nobody had investigated them. There were border police units that were working in the Ukraine that weren't investigated by the Nuremberg people. That it took the German investigators starting from 1958, when the Ludwigsburg investigation unit was formed, to discover these units and then look for the evidence. And that you have to scour the archives and find what references there are to this kind of unit. You look to the military archives as to who was in the units, perhaps the police records. It's an enormous task. It requires a lot of people and a full understanding of what may be available in the archives or not. So you have to have the right people as part of the team, full-time or part-time, giving you advice, but you have to consult experts on historical issues, what's available to help build the situation file. But at the end of the day, in order to prove a war crime, a crime against humanity, you need to charge a person. And you need to find the evidence that links the crime to that person. And if every victim is dead, you have nothing. But if you have people who can testify, people in the unit, documents that link the unit to that particular event, you may be able to put together the case. But the focus at the end of the analysis is what is the evidence of that person's participation in the crime, and what is the evidence of that person's knowledge that he was committing this particular crime? Who are you targeting? Are you targeting the shooter, the person who set off the missile, or do you want to charge the politicians, the head of military, and so on? And I think once you got the situation clear, you try to find out what evidence is available on the various participants, how strong that evidence is. But you have to make sure that you have evidence you can prove beyond a reasonable doubt. This isn't a civil case where the burden of proof is on a balance of probabilities or whatever. It's beyond a reasonable doubt, and that's a pretty high burden, particularly when you're charging a crime of this severity.
One of the questions that came from the public also refers to the Nazi crimes, and it has been asked what happened to all the evidence that you've gathered from the Soviet archives referring to the Nazi war crimes. So what happened to them?
When they closed all of the cases under the Nazi investigation, they were sent to the archives. And I gather they still sit there. We recommended that they go to either university, some historical institute, or alternatively processed through the archives so that they could be accessible to researchers, historians, and so on. What the situation is, I don't know, because I haven't lived in Canada for over 20 years.
Dr. Tsilonis, we have spoken here about the prosecutorial aspects of Armenia, how to do the stuffing, how to collect the evidence. But under the complementarity principle, if the national authorities are unable to prosecute, and in this particular case, let's say, the Armenian the domestic authorities have collected the evidence, they prepared all documents, but they cannot arrest the person. Is it the requirement under the ICC to ask ICC to start its own proceedings on that? Is it under the complementarity principle possible if they are unable to arrest the person?
The ICC does not have a police force, so if the inability of a state is focused on the fact that they cannot arrest the suspects and they cannot have, according to their own judicial system, trial in absentia, like ICC has this rule, then because it's a matter of execution, it's not. I don't think it would be per se a matter of the ICC. We didn't have such a case so far, so it's a much more theoretical question. But we had, as I told you, a Greek case, and I specifically tried to be the first European case at some point in my life. This golden case, the Golden Dawn trial, where a member state was unable to find a venue in order to hold the trial, because it had hundreds of witnesses, there were tens of accused, there were hundreds of victims, and they said the ordinary courts of justice cannot hold this trial, and we have to find another place, or to make another place. So I think they found an old military camp to hold the trial, eventually, after 4 years. So at that point, the inability was for procedural reasons and not actual reasons. If there is inability regarding that they cannot find somebody, I don't think the ICC can stand up, because they don't have a police force. So but they could assist, according to 9310, they can assist a state in order to catch this alleged perpetrator. Because this would be part of the cooperation strategy of the court. And this cooperation strategy does not involve only international crimes. So this cooperation strategy does not involve war crimes, crimes against humanity, genocide, and let's say the crime of aggression too. It involves any other serious crimes, any other crime that would have a serious national or regional impact, or even a crime that it would be very of great concern to a certain state for various other reasons, maybe financial.
Thank you very much, dear Victor, for this clarification. But again, coming to this complementarity principle and the Armenian responsibility of doing its homework on the basis of the prosecution and investigation, which takes, of course, a long time. But can Armenia, under this complementarity principle and, of course, the policy of the OTP that considers or gives this power to the states to do their own task, do the OTP also considers a cooperation from its own perspective to support the domestic authorities to do their homework? Is it something that is considered?
Of course, the new policy envisages that very clearly, and the Office of the Prosecutor is very much willing to support states in order to conduct their own investigations and to build the right procedural mechanism and to conduct this work. So this would be greatly envisaged. Moreover, according to the OTP policy, especially after the Ukraine situation, a country that would be very much interested in following a cooperation court with a court, it would do something else much more interesting. It could say, we offer you 10 seconded professionals inside the court in order to do this task along with your task force. So, for example, in the Ukraine situation, the Office of the Prosecutor had asked and had got more than 75, 80, a great number of seconded personnel, which of course had its own challenges, as diplomatically depicted in the same policy, has its own challenges and difficulties, but it can be very, very good for the court. So that would be another strategy for a state to use. It hasn't happened so far, but Armenia could be the first one.
Okay. Thank you very much. The next question that also comes from the public is for Ms. Hakopian. In your opinion, was that better to sign the Rome Statute or just simply do an ad hoc referral as the Ukraine did? What is your opinion on that?
On this, I will pretty much agree with the Constitutional Court that it was a civilizational obligation for Armenia to sign. If we are fighting for the recognition of the Armenian genocide, then we should by all means join the efforts of the international community to fight, to prevent, punish international crimes all over the world.
Thank you very much. And especially as you mentioned about this false information, which also was spread during, before the ratification and also still is somehow some kind of is present. Do you see any methods of combating these fake news that are referring to the ICC? Because every time when there is a discussion about arrests, or I think the Armenia is not the only country that is affected because of this fake news, but do you see how the public can be more, or how can the awareness be more accessible to the public about the ICC, how it works? Because this is also something that we in Armenia should keep in mind, that the Rome Statute and the whole ICC system is not going to solve the problems of Armenia. Yeah, but how to make this more publicly available to the public?
You mentioned there are different projects and efforts trying to support the Armenian government in the Rome Statute implementation process. One is our project, and we have a component on fighting disinformation. We will be producing several videos explaining to the public what the ICC is about, what Armenia can gain from the ICC and give to the ICC, and also other colleagues and efforts can be implemented in this area. But apart from this, there are several experts, colleagues, who are very strong influencers and public opinion makers, and they usually speak to the public through interviews on social networks, etc. Many of them have also done a lot of work in fighting this fake news and this disinformation. I think it will be needed to keep them involved in these efforts and to continue to work with them as well, because a lot of public awareness can be raised also through them.
Thank you very much, dear Lucia. Especially as soon as we touched up this topic with fake news, and considering also where exactly these fake news are being generated. Coming to the topic, Sarah, you have mentioned regarding the Mongolia and recent developments in relation to Mongolia on the arrest warrant. Could you firstly please elaborate a little bit more on Article 27, which is covering the immunity, that there is no immunity, and on what is then difference between Article 27 and Article 98, which is mostly about the waiver of immunity?
what the ICC does in 22 is like abolishing the personal immunity of anyone. So between the court and any kind of ICC state member, there is no immunity anymore. But the question is what happens to non-state members, and this is what Article 98 is, 98 is talking about. So they are talking about a third state. So the third state is a non-party to the statute, and it is also talked about the horizontal, the vertical, and the triangular relationship. And the horizontal relationship is between the ICC and the member states, and between the member states there is also no immunity anymore. But once more, if there is a non-member state, it comes to a triangular. So we could argue that maybe in front of the ICC there is no immunity, even for the non-state member. But what is with regard to the international obligations from state to state? And this is what makes it a bit more complicated. So one could argue that Mongolia is not obliged to arrest Putin because Putin is a part of a non-state member. But as Jordan did in one of its decision, it said, no, it doesn't matter because it is now international customary law that immunities are not applicable anymore. I don't know whether you could argue, I mean, maybe in front of the court, but between states, I don't know whether personal immunity is really abolished. So one could either way say, and now taking maybe the fact that Armenia has to arrest Putin if he travels to Armenia, one could say, okay, they say under the ICC, maybe we are not allowed to do this because we have the international obligation, but we could break that and violate that because in the end it is more important to arrest someone who is responsible for the crime of, for any kind of crime, war crimes and so on, than saying we are sticking to the personal immunities under international law.
Thank you for this clarification. It's thank you very much, Sarah, for this clarification. I think this is something that we will still, I think many states will still have this problem with the arrest warrants. I hope, according to the Nuremberg principle, actually, which is the outcome of the Nuremberg judgment, there is actually no immunity for international crimes. This is something that is also already a part of international customary law. But, of course, there are other politics that somehow are being involved in. Moving forward, with the implementation of the laws in Armenia in regard to the ICC. Lucine, you correctly mentioned that there are already some developments. But do you think that besides of this or these developments on the legal basis, what other issues or what other laws should be still drafted in order to support Armenian authorities in cooperating with the ICC, besides of already the law that is already in a draft? Do you see any other possibilities of having new laws and more connection with the ICC?
Thank you very much. I think one area of legislation that will definitely need to be addressed is the Criminal Procedure Code. As I mentioned, there is still a discussion, but these are really like political decisions to be taken, also after discussions with competent experts, whether we will need these changes, amendments in our judicial code. Maybe we will need a special chamber in the cassation court or even specialized court. These are decisions to be taken after really deep expert discussions, and after all, these are also political decisions that should take into consideration the resources of the state, etc. But yes, these issues need to be discussed.
Thank you very much. Considering that Azerbaijan is also not member state to the ICC, and also there are some similarities with Russia, if there, let's say, sometimes there will be some discussion about possible arrest warrant on Aliyev. Apparently there will be the same discussions because Azerbaijan is not member state to the ICC, so there will be another immunity problem. Dear Victor, how do you think that in this particular case, considering membership of Azerbaijan, how can ICC help in that case Armenia dealing with these cases and, on its own soil?
Okay. First of all, I would like to say that I think it's very important that Armenia ratified the Rome Statute even recently, because what has happened in the past will most certainly happen again in the future, as somebody has said, and that is very good in order Armenia to be legally protected in the future from hostile activities and illegal crimes that other countries, including Azerbaijan, might do. For me, the most serious legal problem regarding the Nagorno-Karabakh and Azerbaijan-Armenia relations is not so much the geographical one, but the temporal time. One thing that Armenia could arguably do, it's a big theoretical discussion, is Armenia could invoke Article 12, Paragraph 3, and retroactively accept, even now, arguably, the ICC jurisdiction for crimes that have taken place before Armenia ratified the Rome Statute, and this, as I heard earlier, it was concluded on February 2024. So that would be one strategy to do that.
Thank you very much. Mr. Kremer, in your experience with the cooperation on the prosecutorial level, what are the biggest challenges that the prosecutor face if you need, for example, the need of the local knowledge of the prosecutors? How this cooperation of the prosecutors on the practical level works?
Nazi war crimes cases where we were dealing with the Russia and the former Soviet republics. The cooperation worked by initially traveling there, finding out how cooperative they were prepared to be, signing a memorandum of understanding, setting that out, and then taking the next step to try to implement the memorandum of understanding. Initially, I went along with our historians and investigators, and we had a plan set out as to what we wanted to accomplish, and we had written communications beforehand, and then the prosecutor authorized it. In some cases, a deputy prosecutor came along to archives and supported us. We had one example where the chief archivist at the National Archive of Ukraine in Kiev wouldn't let us in. And so we went back to the prosecutor's office and we said, we have a problem. And he said, okay, we'll go visit tomorrow. He went and he came with 2 armed policemen, and he said, if you won't let them see the finding guides in the file, I'm going to seize the archive. And so she thought about it for a while. She was very well connected, but realized she didn't have a choice, and we got in. And we moved from there. At one point, the KGB archives were difficult, but we broke the barrier by persuasion, and they let us into the KGB archive, but they insisted they sit in the room while we looked at it. It's no problem for us. And then it worked further, and then we went to the various regional archives and did the same thing. We got into Lviv. Can we get in here? Yes, yes, yes. And then we went to Kyiv and said, can we get in? And they let us in. So, and we did the same in Moscow. Once we figured out the system, the reporting system, we knew where all the files were. We knew how the reporting system worked. And when somebody in Moscow said, but we don't have those files, we can say, yes, you do. And then they give us access. So it's a matter of being, how can I put it, diplomatic, but assertive, and never giving up. Always have hope that you're going to break through and get it done. But we also had a number of very expensive dinners with prosecutors and deputy prosecutors, which is part of the way you do things over there. And in the former Yugoslavia, it was when the breakup of Yugoslavia occurred. It was basically the same, and then as the political situation shifted to a more open-minded administration, we got into archives and so on. And that really didn't change the quality of our case, but it changed the strength of our case and gave us more precise information as to what the political players were doing. So always have hope and be patient. That would be my ultimate advice.
Fantastic. This is, of course, the cooperation between the prosecutorial level, but then coming to a little bit on the political level. Sarah, you mentioned about the ASP, Assembly of States Parties. And those who are not familiar with the ICC system, there is like similar to the European Court of Human Rights. There's the Council of Europe, a little bit, of course, different institution. However, at the ASP level, Armenia is becoming a member to the ICC. What should be actually the role of Armenia in the ASP? You slightly touched that topic, but I think it would be great to a little bit dive in.
Yeah, first of all, I think it's very important for Armenia to participate in order to show presence and to be part of that criminal, all the criminal procedures, because in between the ASP, they really have also the power to change things, to bring up new things, or if there are unclarities. So I think this is what's important. Then as a negotiation expert, I have to say it's so important for them to build alliances also, because you never know what will happen. So in the end, we saw it's all about the cooperation. So it's all about states, so it's all about political. And so it's very important to build alliances in order to assert pressure on certain states to cooperate with the court, for example, but also to build like judicial procedures and things like that. So I think it's very important for Armenia to be present.
From the civil society perspective,
and also there are already a number of exchanges between Armenia and ICC, and several delegations have visited the ICC this year, and one delegation also visited with the support of our organization, Dr. Petrossian, headed by the Minister of Justice and President of the Supreme Judicial Council. And I think I couldn't agree more. The participation, presence also helps a lot in understanding what the essence of Armenia's obligations are, and also these exchanges will help the authorities build this network of also experts, relations, stronger cooperation.
Victor, please.
Yes, thank you. It is very important, of course, Armenia to participate in the Assembly of State Parties. There are two groups, one in The Hague and one in New York, with diplomats that they meet regularly and they discuss the ASP work throughout the year. And of course, along with this burden of participating and preparing drafts, discussing the whole year about a draft about a single line that changes every 2 weeks or so. There are also opportunities and their rights. So, for example, Armenia can propose his or her own judge in the future. And I will tell you a small secret. It has never happened before, but it can happen in the future. This judge does not need to be Armenian. It can be of any nationality. I mean, member states so far have adopted, as far as the judicial proposals, judicial nominations, a very narrow view in too many respects. One of them is that they usually choose a national of their own state. But if a state would wish to increase its chances of having somebody, it could choose someone who is not a national, and according to the regulations, there is such a right.
Mr. Kremer, you wanted to add?
Yeah, just on the subject of patience and hope. When we had arrest warrants for Milosevic, Karadzic, and Mladic, given the current political situation, we didn't have that much hope. But there was always pressure being applied by the prosecutor, by the Americans. I think you were applying pressure on behalf of the American government and by other European governments. Release. Slobodan Milosevic lost power. 3 months later, he was in ICTY custody. That was better than what we had hoped for. Karadzic, when he lost power, it took 12 years to arrest him. He went underground with the help of the Serbian security services and changed his whole persona, had a long beard, long hair, and was a faith healer. And then Mladic was protected by the Bosnian army for 15 years. Then he got sick, and they turned him over, and he got healthy again in Den Haag. So, and Karadzic and Mladic are serving life sentences, and Milosevic died during the course of his defense. Whether he killed himself or not is still open to conjecture. But there is hope. I've seen it come true.
Sarah, please, you want to add also something?
Talking with the, it's on. Talking with the prosecutor Ramatz, and they were still free, and we were talking about it, and it was also about the cooperation. And in the end, it's the same with the ICTY as the ICC. So there is the only pressure you have is the pressure of states in the cooperation. And he kind of smiled at me, and he said, Serbia is very interested in getting a European member and things like that. And then, exactly as you say, 3 weeks later, I was opening the newspaper, and it's like, okay, now they met, and this is what has happened. So you can really see the whole cooperation of these courts is dependent on states complying, but on the other hand, exerting pressure. So in the end, this is what it is all about.
So coming slowly to the end of our panel, I would recommend that maybe each of you will have closing remark, what exactly Armenia should do, or your recommendations to Armenia regarding its role and responsibility as a new state party, and then we will summarize this panel. So starting maybe Lusine, with you.
Take seriously the need to amend legislation to comply with the ICC obligations, to do as much capacity building as possible. We need to have really professionally trained people in the relevant public institutions to be able to become a full member of the ICC, to really treat this subject seriously in the law faculties of the country's universities, educate students, teachers, papers, translate professional literature as much as possible, really be very active at the level of also state institutions, not to leave it up to civil society only, but really engage. And this also concerns Armenia's Human Rights Defenders Office and other state institutions in fighting this disinformation campaigns on ICC, and also, aspire also to have Armenia's judge in the ICC. Thank you.
Kind of said everything what I also covered. I mean, I think the implementation into international law is of paramount importance, but also what we said, or what you said with regard to complementarity, also to have such a criminal structure that Armenia itself can prosecute these crimes, and I think this is the most important, and also to see, I mean, they are really looking for justice for themselves, but also implementing justice for maybe all the others, and to be a strong partner to the ICC. And if it has questions, it can always really talk to the registry, to the Assembly of States Parties, to the OTP. So really to be a strong partner, I think that's the most important, to make this cooperation as strong as it could be.
Thank you very much. Victor, please.
Thank you. If Armenia wishes really to participate in the work of the International Criminal Court, and I will speak quite boldly at this point, it must fund certain activities. And if it wishes to take this serious role, it must fund these activities because the court has a very limited budget. So one measure would be to sign an agreement or see how to send, as I said, seconded personnel to the ICC, to the Office of the Prosecutor for certain reasons, or for the investigation of a certain case or a certain situation, or just for experience and capacity building. Another thing would be to request from the Office of the Prosecutor and the registry, the chambers, for capacity building, and to see how to make this happen. Having a field presence in Armenia would be great, but this will need funding. So again, we return to this, who would finance these things. Thirdly, as noted, to have nominated a judge, an Armenian judge possibly, yes. What would be a drawback is that if Greece has a Greek judge with a Greek nationality, this judge must necessarily abstain from his or her duties if a case concerning Armenia comes before the ICC in 5 years. But if he's not Armenian, I don't know, we should discuss this further. Thank you so much.
Thank you very much. Mr. Kremer.
I had anticipated this question, thanks to Gurgen. I think what we've learned is that while Armenia can refer the situation to the ICC, it's not going to happen successfully unless it does a fairly extensive investigation of the available evidence and establish the requirements under the statute. If you read the policy paper that Victor talked about, the prosecutor talks a lot of mumbo-jumbo, but the essence of what he says is the burden stays with the state, and we're only going to participate in extreme cases. This case is not a simple case like the Ukraine, Israel, Palestine, and so on. This is a complicated case given the diplomatic dialogue and the lack of evidence about the orders given by the Azerbaijani political and military elites. So you should carry on the investigation as far as it can be carried out. You've done a lot of excellent work by this organization in interviewing witnesses. That should continue. Be mindful of the pitfalls of NGOs interviewing witnesses. There's a policy paper that the prosecutor put out in 2003 with NGOs talking about what should be guarded against. That's worth reading. And I agree with Victor that what is very important is start a dialogue very soon with the prosecutor and find out the capacity of the prosecutor to help in your investigation and where the priorities should be. But in terms of the prosecutor may be best able to help using his cooperation powers by sending out requests even to Azerbaijan, even though they don't answer them. They may, who knows, requesting military documents for the period regarding the events and so on. But he wants, according to his policy paper in 2024, he wants to cooperate with states conducting investigations and take him up on his word. The problem is has been recognized by speakers already. The budget is limited and the staff is limited. They're up to their ears in work. So secondments work. I don't think an Armenian sent to the ICC should be seconded to the Armenian file. Should be but they should be there to learn, and to the extent that you can send more than one person, an investigator, a prosecutor, even somebody in the support staff to learn how these cases should be organized, that would be very, very helpful.
Fantastic. So this is actually the moment that we need to conclude already our panel. I think this was very insightful and very powerful to hear the experience coming from the different aspects. And I think some sort we can really say that by organizing, by having all our guests here during this conference, somehow we fulfill also our complementarity requirement. So thank you very much for that. I would just want to thank all our panelists for coming here and sharing their experience and ideas. And yes. And of course, I just want to remind you that we have 15 minutes break.